You're listening to a Pop House Network podcast for developers by developers. Welcome to Java OffHeap episode 61. Hey everyone, I am super excited about this episode, because this is, hopefully the conclusion of a long drawn-on saga if you have been listening from the first episode, you know that we have done like Oracle versus Google every now and then as the things. And I think finally in this episode we can wrap things up. But before we dive in, there's two things. First, if you're new to the show, my name is Freddie Kime. I'm a principal engineer at Expedia, Java champion, speaker, author, also like Seattle Java user group co-organizer. I'm here with my usual suspects.
Hey everybody, this is Bob Paulin, independent consultant from Chicago, Apache Software Foundation member, Java champion, and CJUG board chair.
Hey everyone, I'm Josh Juneau. I'm a Java EE and Jakarta EE developer by day, and also an Oracle DBA. I'm an author and open source developer by night, Apache NetBeans committer, JCP member, CJUG board member, and Java champion.
Hi everybody, Michael Manella, member of the Spring Engineering team, author, speaker, chairman of the Reactive Fund Governing Board, as well as newer, it was on the last one as well, and curmudgeon at large.
Oh, that's all.
It's my favorite title. Like that's my favorite of all. No offense to any of the other one. But
before we dive in, this episode is sponsored by Datadog, a monitoring and analytics platform that integrates with over 400 technologies, including AWS services, Docker, and Kubernetes. Datadog's platform brings together metrics, traces, and logs in one place so you can get full visibility into your environment and improve your application performance. With machine learning-based alerts, customizable dashboards, and distributed tracing, Datadog makes it easy to unify disparate data sources so you can troubleshoot faster. Start your free Datadog trial today. Listeners of this podcast will receive a free t-shirt once you install the agent and create one dashboard. Visit javaoffheap.com/Datadog to get started. Again, the URL is javaoffheap.com/Datadog. We thank them for keeping these episodes going and, the mic's on and the beer is flowing. So give them a shot.
Speaking of which.
I have a double for today's episode, so it's going to be fun.
It's getting close, hopefully close to the end of pandemic, right? Maybe we'll be able to do one of these in person in the next couple of months.
In summer, hopefully.
There.
Yeah. We'll be fully vaccinated. This will be a thing of the past. I'm so looking forward to it.
Got my shot.
Yes.
Nice.
All right. Well, let's dive into it. Let's first go into the news.
Okay, well, I'll mention first that Jakarta EE 9.1 is due out in May. What's part of Jakarta EE 9.1? Well, it's Java 11 support. So, lots of us who have been Java EE and Jakarta EE developers have long since been waiting for Java 11 support. We're still working on JDK 8, so it'll be nice to have that.
Yeah, it's actually funny. I ran in my first project ever where there was something in 11 that I didn't have in 8, where I tried to run it in 8 and I got the method not found error. I was doing things with maps. I was trying to create just an immutable map, but without instantiating a map and doing all the put commands because it was in a constructor. I was hitting a super constructor, so it had to be the first thing. And I ran it in Java 8. I'm like, wait, it doesn't work.
Oh, well, like the map off. Yeah.
But it's finally here. I mean, and people have been using it for some time, so it's good to see that it's getting the kind of support around the community.
Definitely is. And another thing to remember about Jakarta EE 9 is that now we are using the Jakarta .star namespace, Jakarta namespace. So
you don't want to get sued.
Get ready to refactor your code.
The theme of this episode. Or if you get sued, you want to win.
Yes, either one.
Anybody using Jetty? The reason I asked,
not in production.
Not in production.
Jetty, yeah, just Jetty.
It's now Jetty 11 now supports the Big Bang. It's moved to the Jakarta namespace. So if you are using Jakarta EE 9, you can now use Eclipse Jetty 11. So that's a new one. And that's compatible with Jakarta Servlet 5 and all the other goodies in Jakarta EE 9.
So supports Big Bang? Is that the name of the Jakarta EE 9.1 release?
No, so
That was 9, wasn't it?
9 was the Big Bang release. They called it the Big Bang when it moved from Java X to Jakarta namespace.
Got it.
Big Bang because we did it all at once, right? Got it all over with. So that's news for Jetty. Another one would be, I'm sorry to be hogging the limelight here, but
Josh, this is your episode. Hog it.
Yeah. GlassFish 6.1.0. That's going to be aiming for JDK 16. So GlassFish 6.1.0 is not yet anywhere to be found. You may be able to go and get some kind of a build to build, but there are no binaries available yet for this. But it's in the works, and it will be targeting JDK 16. So that's a pretty good target, I think, especially for us who are using JDK 8 still. That's double the amount of JDK, right?
Damn.
Now, when you say it's targeting it, are you saying that it requires it, or that it's using some of the new features? Actually, I'm not sure I follow that.
Oh, that's a good question. That is a good question. Let me take a look.
Because it would be interesting if you couldn't run GlassFish below that version, right? Because if it's compiled, usually, you have to use that version or above. So I just followed your link. It says JDK 11 is the minimum for 6.1.
Right. Yeah. So it's going to be 11. Because 11
will be the minimum. Okay, got it.
It supports for 16. Okay.
Okay. Yep. But you can't run it on 8, so you got to upgrade there.
Yep, got to be 11. So now we're
I wonder if they use like multi version jars, or what is it like the
the multi-release jars. But yeah, you can do that in
OSGI
9 plus.
Yeah, it has to be 9.
That OSGI lets you have multiple versions of stuff in it.
Oh, absolutely. But this is multiple language features, right? So the multi-release is actually well beyond what OSGI can do.
Yeah.
That's like dark magic, the multi-release thing.
It gets very confusing. No.
Yes, it can be.
So that's pretty exciting news. Another thing, couple of IDE updates. We have NetBeans 12.4 that's in beta testing now. If you're looking to use NetBeans now or in the future, go grab this, download it, and start to play with it. Let the team know if there's any issues. Just to name a couple of the features, they're going to have Jakarta EE 9 support in this. There's lots of bug fixes that are being repaired, updating JavaFX to 16. So too much to name, but lots of features in there. So go grab it and check it out.
Seems like every episode, Josh, you got a NetBeans update. They seem to be doing a lot more releases now that they're at the ASF.
Continuous deployment.
Yeah, no,
yes,
it's a good thing.
Yeah, it's releasing 3 times a year, I believe now. So it's keeping on the move. So it's going pretty well.
And not to be outdone in the next one, you've got JetBrains. I feel like they're all on a cycle now, right?
Competition is good.
Yeah,
not to be outdone.
Yeah.
2021.1. This introduces Java 16 and WSL2 support, space integration, code with me, a HTML preview window inside the IDE, the option to run code on SSH hosts and in Docker containers.
Oh my gosh, they have WSL2 support?
That's what it says.
Damn. Now that's like, usually they're fun, but that's big for me.
Yeah.
Damn.
This does look like a huge release for IntelliJ. If you scroll down the list and look at all the release updates, Kotlin features, Scala, if anybody's using that. We've got, and if you go to Ultimate, there's even more, lots of great
goodies.
JPA console for Jakarta EE 9, which is nice. Color scheme for UML diagrams. So lots of nice things out there.
Nice. And And just to continue with IDE news, I started a new client a few weeks ago, and my first thing was adding an Eclipse project plugin to all their IntelliJ projects. So now all their SBT plugins have Eclipse project generators, and there's a new version of Eclipse out as of March. So they've continued on their quarterly release schedule. For folks looking for anything from that, I installed it. It was a pretty much a non-event for me. Everything worked. Didn't really see a lot of new features in it, although there might be. But continuing with their upgrade cycle that they've got that Eclipse IDE on. So if you're not already getting auto updates, try it out. Was completely non-event for me.
That's awesome.
Nice. Hey, I have a question. So with Eclipse, do you have any support for like Jakarta EE yet in that, or microprofile or anything? Because I haven't really looked at Eclipse lately.
I haven't. I don't usually use for any IDE any of the really templated out things. Now Eclipse does have a Java EE developer
version, right?
Yeah. But and that's usually the one I install. But I always use the plain Java perspective.
Got it.
So they do have tools in it, but it's not something. Most of the tools I'm not a big user of. I'm still one of those folks that like editing XML files and looking at kind of the raw configuration rather than using tooling. So I'm
no magic.
There may be support, but I'm the wrong person to ask.
Gotcha. Sounds good. And then I think next up is something we can all talk about here is JDK 17.
Ooh.
Early releases and timeline. So
yeah, this is the LTS, right?
Yep. This is the big one. Should be in September? Is the final? September 14th.
Yep.
Yeah.
Gosh.
So if you look at the list,
features, though, there's not. It's kind of a small feature list. So I wonder if they're getting a lot of polish, focusing on a lot of polish and stuff.
That's what I would expect. Is that this is a polished release for everything that's coming.
You don't rock the boat on this one. Yeah.
Exactly, because this is the one that everybody's going to upgrade to. This is the one that's going to move people from 8. Like if you look at all the other features. I don't think 11 had a lot of a ton of movement. I really don't. 8 still supported, so it's not like you had to move. Mm-hmm. And what did 11 buy you other than taking a leap and to figure out whether or not you're going to be bit by the module stuff? Like beyond that, there was no benefit to moving to 11, right?
There's the ability to create maps of.
That was helpful for me recently.
No. But you get stuff for free, right? Like the thing from 8 to 11, I tend to agree. Like VAR, I love it, but it's like if I have to go out, like if I can definitely be without it. But it's all the performance improvements you get for free, right? That's a big thing. Mm-hmm. Like a lot of these are drop-in, and suddenly if you're on the cloud environment with the charge you per CPU cycle they use, it's like, oh, I just did an upgrade and I'm saving.
But when you consider I think traditional enterprise stuff, where in order for me to upgrade my JDK across all the different apps, because there's the standard JDK for my enterprise, right? And so with that, I need to now retest and revalidate all of those apps, which means I need to spend money for what concrete benefit to the business. And that this is a conversation we've been having quite a bit actually internally for where I work with regards to the cost of there's a concrete cost that a lot of software people don't think about with regards to well, it's more than an inconvenience. There's dollars and cents associated with this. Because like I said, in order for you to upgrade from JDK to 11, you had to spend time with QA. Deployments had to be redone, like all those other things, and that costs money, both paying your salaries as well as delaying features that you could have been working on instead.
So the interesting part is, right, like if you use containers, the CI/CD pipeline is not touched, right? So you can, as long as your Docker starts, the rest just sells through. And
that's a really high assumption of maturity. At least in my experience, for a lot of enterprises.
I'll say there's pockets, right? Like for example, where I work, you can still find CMake, but there's a lot of the interesting part is like with the microservice push, where every smaller piece of functionality they became as microservices. The good part about it is that then it allowed them to have independent sort of like evolution, right? So on that side of microservicing, like for example, we sort of bank on that where we work with, where we can, if somebody's ready, they can just say, okay, here's my Docker image. Because I control my CI/CD, because this is for my microservices, I can do it however I want. So I will say it was rare probably like 3-4 years ago, but at this point in time, people are like, even with Kubernetes is something that we're like, we have big pockets, but it's not everywhere. CI/CD and Docker is more common, way more common, I'll say.
I'd say you're probably ahead of the curve. Just my punch. Bob,
I've seen it in a lot of different forms. I have clients that are still building where the JDK is installed on the build server and it's built there, and other ones where it's Docker and Docker type of builds, where it's even the build environment is containerized. Java's not even installed on the build servers. You just have Docker and it downloads it and builds it and kicks it out into another Docker container. So you run the gamut, but I guess for me, the thing that's missing, even though it is a long-term release, is I was really expecting to see more Project Loom and kind of Valhalla stuff in here as sort of to entice me to really say, hey, guys, you need to go up to this next LTS because there's some meat in here that you're going to need or want. It's like, well, you can learn reactive or you can switch to Loom, and obviously those are not completely independent.
Thank you.
That's a can of worms.
We're having that debate right now.
Where I'm going with that is that at least, there's nothing I see in this release that we can even really debate about as far as big features. It really does look like a polished release for the JDK team, rather than something where where they're trying to pull people up to that release.
So I'm thinking that Loom is going to be in JDK 17. It's just not on this list yet.
Not on the list yet? Sure.
Well, I mean, if you Google it, it does show up that it is in EA releases, JDK 17 plus 13.
Oh, so it's going to be like a flag, okay. So
yeah,
and maybe that's fine. Maybe we're just too early in the ramp, in the cycle for it to be there. But that's, again, against my expectations looking at this list. There's nothing that gets me super excited about it yet.
I mean, like I said, my expectation is the excitement around 17 is now everything you've been waiting on between
11 and
and 17 is now blessed. Now, as an enterprise, I can actually grab it.
Yep, 16 was the big one for me. From what recently, I think with all the features.
Yep.
All right. Let's move on.
So I did the next one. So speaking of reactive, for those of you who have never heard of it, R2DBC is a spec within the Reactive Foundation for basically building reactive database drivers, reactive relational database drivers. And Oracle released one. So they're probably the biggest name out there that's actually released one. What was interesting with this one is when the spec came out, the spec was originally developed by Pivotal at the time, now VMware. We approached Oracle and they didn't want to do it. They actually said they were going to use Loom, and they built an asynchronous Oracle driver, and that was the direction they were going to go. And since then, they've walked away from that, and they decided to implement their R2DBC driver. So really exciting to see them getting on the React and supporting that spec.
They didn't just do mono from future, right? Like it's not something like that.
Correct. The other one I had on here, and I'll keep this one quick. This was hot off the presses news at close of business today. Dell is going to spin off VMware.
This is when Michael just gets silent.
No, I'm willing to share what's in the press release because, frankly, right now that's all I know. Anything that's more secret is way above my pay grade. And so for those of you who don't know, Dell originally bought EMC, which owned an 81% stake in VMware. So EMC owned an 81% stake in VMware. Dell bought EMC for 67 billion. Like it was a absolute truckload of money. Largest acquisition in IT history. And quite frankly, IBM or Dell needs some money. They got a whole lot. They want to do a whole lot of debt to buy that thing. And so because of that, they're spinning VMware off. The reasoning behind this is purely my 2 cents. Is there's nothing official or internal on this. Thoughts or opinions of my own on that. But yeah, so they're going to spin off the Dell, or they're going to spin off the VMware piece of what was EMC. And so it'll be its own independent, not really controlled by Dell anymore. And so there will be Dell's or VMware is going to buy a bunch of stuff. They'll get an extra dividend kicked out. The finances are all available online. So yeah.
Yeah, we'll have to take a look at that because I mean, if it market's high right now, so it's up. So if you're going to be taking profits or getting cash back, and I don't know what the terms of the deal is, but there should be something going back. So
there's a dividend of what is it? It's like upper 20s. It's 25, 30. It's like 27 to 28, 27.43 to 28.62 per share for all stockholders of VMware stock. That includes Dell and.
So somebody's buying the next round.
Yeah, when I see it.
After taxes and everything, is like
exactly. Yeah, so, yeah. So
that's we can discuss that until the end of the day of the world. Like,
well, moving on to the next topic that we can talk about till the end of the world, or maybe not.
Because we have been.
Right. So Google versus Oracle. Did something happen there, Freddie?
Oh my gosh. Yeah, the big drop. So finally, the Supreme Court picked up the case, make an announcement. They make a, how do you call it? Like a judgment? I don't know how do you call it. And then all this legal terms that we've been reading all day long. And technically, I think it's done. So that's what we wanted to dedicate this episode on. And I think, and then cue in like the music, and we're gonna go back in time to where it all started.
Yeah, because this didn't just come up and get resolved very quickly, right? So we've been talking about this since our first episode.
Oh my gosh.
1, and we're on 61.
Yeah, so
so for those of you sick of hearing it about it, maybe we're finally done. We hope.
Maybe. It depends on what wants to do.
We'll see though.
All right.
So
is this Freddie, the first slide? Where does time begin?
It all started
evolution.
In the small when humans walked the earth, and then with dinosaurs. No, so I mean, this is just some background before we dive into the timeline. Like, this is a monumental case because it's essentially deciding the copyrightability of APIs. If you ever implemented any kind of like interface, that's that's sort of like in a broader or restricted scope, like how that interface is copyrightable, and whoever created that interface, how much sort of like can go after you because you decided to copy that interface. And it's essentially, we always thought that was monumental for our industry, and that's why we were so keen to cover it. But it all started back in when it started. Essentially, Oracle versus Google. It started back in the day when first Java was released, right? And then that is where we go into timeline. In 1990, Java, Sun started developing Java. Java was released on 1995 under what is called the Sun Community License, where Sun still maintaining control of the TCK, the Java SC, Java ME.
And the thing to remember is, I mean, at this point, open source does not exist even close to the form that it does today. Like the ASF doesn't exist. You know, the Apache web server is still in its basically its infancy. So, I mean, this was just how software is built. It was a corporate owned and built product.
Yep. Yeah. No, and you know, we've gone a long way in 30 years. Gosh, 30 years. Damn. All right. So then what happened was, you know, Android, you know, the big player that wanted to, you know, now Android is everywhere, but at the time started in 2003. And Google saw the opportunity because they wanted to get into sort of like that mobile space, and they bought it in 2005. So the thing that happened after that was that Google was looking for, you know, developers. App were all the rage in the 2000s. Everybody wanted to have an app for everything on their phone. And Google wanted to seize that opportunity. And interestingly enough, in 2006, Google and Sun Microsystems actually sat down to try to talk about like, oh, can we use Java for your thing, right? And we're willing to pay $30 to $50 million for it, right? Like for a 5-year, I think it was like a 5-year license deal. And things fell through because what happened was Google said that Oracle wanted to keep essentially one of this like revenue sharing process where, you know, they get some commission for every Android operating system or every Java SE that gets installed. Oracle or Sun.
Well, and this was a weird spot too, because this before or after Oracle announced they were going to be buying Sun? Because
this was before. This was before.
Okay, this is before. So we've got Sun still involved. They're talking to Sun. But I know there's a number of things that are happening on this timeline where like the purchase isn't done and it was talked about. And
Yep. No,
I wasn't sure if we were in the gray areas yet, because this stuff becomes very important in terms of the ruling and why it was ruled the way it was. So.
Because what Sun was saying is like, oh, what Google wanted to do is sort of like fragment the system, right? Like again, the promise of Java at the beginning was write once, run everywhere, right? So you know, Google and Sun tried to talk about it, but no deal was made. This was 2006. You know, and then because of like, this is sort of like the years that they're still building like the open source movement, and we're starting to see open source as we know it today, right? In 2007, you know, pressure from the community, Java was licensed on the GPO with the class path section, which is the one that we all are familiar with now. But, you know, like before 2007, this was not the case. You actually had like, you know, Sun actually control all the parts of Java SE or the license of Java SE. So
that's what really opened up a lot from a licensing perspective to build on top of Java.
Yeah.
We use Java to build products and whatnot.
Yeah, because GPL by itself would have generally meant any of the code that we built on top of it would also need to be open source. But so the significant addition here is that class path exception, where the code I write is now excluded from the GPL license, so that while if I need to make a change to the runtime, that would need to be contributed back if I'm shipping or you know, all the various clauses on GPL. I'm not a lawyer. But my client code is protected as not needing to be GPL'd. So I can
if you're consuming it, however I link into it.
And that was important to open source. It was important to companies. It was important to everybody that they did that. And the GPL with class path exception still exists with Java today.
Yeah. And so once the Java was licensed in the GPL, things that were fast follower is that OpenJDK was released in 2007, and Google looked at it and tried to say, like, can we use this? But at that point in time, OpenJDK was not at parity with what Sun's Java SC looked like. And so they were like deciding, like, we're probably going to pass on OpenJDK. It's not mature enough for what we want to build. So in 2007 itself, again, they decided we're going to pass on this. And then later in that year, Google develops what is considered a clean root Java SC libraries into Dalvik, right? Like, which is the Android sort of like virtual machine. Copies from Apache Harmony, which is an open source project, and that's the big 37 calls, 11,000 lines of code that were copied from the Dalvik for the quote-unquote clean room implementation. And then later on that year, Google released the Android SDK with included Java technology, which is, essentially the APIs that were copied and some of the SQL structure and organization that is going to be the big thing that happens, right? Now, so that was in 2007, and then comes Big Red, right? Oracle, then in 2009, by Sun. And so, Big Red decides to, 2 years into it, or I think 3 years into, or I guess 4 years into it. No, actually, no. Essentially, between 2009 and 2011, decides that, look, I think what Google did was wrong. They copied our APIs, and litigation starts, right?
Amazing the coincidence in that timing.
I wonder
because Oracle doesn't have any history in litigating or nothing like that.
And this is the reason why we are going to be banned from going to Java 1.
Java 1 doesn't exist anymore.
Yeah, Java 1 doesn't exist. And if they haven't by now, really? 5 years of us doing this.
Yeah, we're the small fly. They're just annoying. They don't, there's nothing. They'll get some
fun guys.
Some beer. That's all what they're gonna get from us.
But yeah, obviously the litigation spooks the ASF with Harmony. I don't know that we have a line where it started, but the Harmony project, just to give some background there, was meant to be a clean room Apache licensed implementation of Java. The reason Google went with Harmony has a lot to do with the fact that was kind of what they wanted. They wanted basically a liberally licensed JDK runtime that they could ship out that didn't have any of the concerns.
Encumbrance.
Yes, that would come with a commercial license. But the ASF in its hey, we don't want to get sued mentality says no more.
Which is fair.
Yeah.
Which is fair. They decided to essentially maintaining the Apache Harmony project in 2011. And the fun fact, right, up to today, the Java trademark is still owned by Oracle, right? So one of the things that means that even if you create exactly the same thing, and it does exactly the same thing with the same libraries, you cannot call it Java. Because for that you need to essentially ask for a license from Oracle, which usually involves running what they call the TCK or test compatibility kit, and that's how they get their money. So even I think that's the reason why Apache Harmony is not called Apache Java, or Dalvik is not Android Java, is because they cannot call it that, because they never actually got a license from Sun at the time or Oracle now. So after that, in 2013, Google actually replaced Dalvik with what is now called the Android runtime. And but the Android runtime still uses Java SC API, and I think at that point in time, OpenJDK did play a figure on that replacement. So that is sort of how the events unfolded. Google started essentially trying to beat to the market, and it's kind of funny because history repeats itself, right? When Java was conceived, it was done with the intent of making it easy for C++ developers to adopt it. So a lot of the syntax of Java, at least at the beginning, now it's looking completely different, was taken from C++. The way you define classes, objects, the way that your sequence statements and all that was actually taken from C++, because the idea was I want to just get C++ developers to start adopting this. And Google sort of had like the same idea, which is, I want Java developers, which is there used to be a lot. There's still, even if they're not more, but they were one of the dominant developer, or I guess with C++ and all kind of developers that were out there. They wanted to make them easy for them to transition to the Android ecosystem. They wanted to do the same thing, which is we're going to use something Java-like so they understand what they're doing and they can just immediately be productive, right? But once the litigation starts, we get into this big timeline on what actually happened, right? So it all started in 2010. Oracle sues Google. Oracle acquired Sun and all the IP rights to the Java programming language and all the TCK and all the IP. Sues Google for copyright plus patent infringement. There were patents that they say that they actually broke, right? And then Judge Alsop, takes the case in 2010. It splits it into three parts of the argument. The first one is the copyright argument, the patent argument, and if any of these actually turn out to be like that Google is at fault, then the damages, what the damage should be, right? So, April 2012, 2 years later, the copyright phase starts with range check, which is a method that allows you to check if an array is, you give it an index and an array, and then see if it's within that particular range, right? And if you are, if you're a beginner or even intermediate, if you're an intermediate or even a beginner developer, the implementation of range check is 5 lines of code. Like, it's super trivial, but it was considered like, oh, they copy it from the Java SE ecosystem, right? So then they did say that the jury said that in the copyright part of the phase, they say that Google did infringe on codes, what is called SSO, which is a structured sequence organization, meaning like how the APIs are organized. And they say that yes, Google did copy them, but they deadlock if the copy of these things that were copyrighted fell into fair use. So what happened is sort of like that was the jury was deadlocked on that particular part. Then they sort of like say, okay, Judge Alsop was like, okay, we'll start the next phase and then we'll figure out what we're going to do with the deadlock, right? So the patent phase starts. Google found non-infringement with the patents. That was a win for Google. That's what there's a little star in there. Then Judge also takes all the information that he got from before, and I have to say, like, this is the actual judge that learned how to write a bubble sort. I think it was a bubble sort algorithm, but essentially he implemented an interface, which is why, like, of all the judges that deal with technology, he is my favorite just because of that fact. He actually took the time to try to understand the thing, and he will be my, like, I don't know on many judges, but he will be like one of the judges that always go back to, like, this is the way to do things, right? So once he realized that, implementing an interface, I can implement an IDE each way, and the interface is essentially like a sort interface. That shouldn't be copyrightable. So Judge Alsop issued a verdict that APIs are not copyrightable. That was in May 2012. Of course, Oracle does not like the decision. Goes into appeal, Google cross appeals, and then it goes from Judge Alsop, which is a local court, it goes to the Court of Appeals, and they see things differently. They say that API packages resemble a taxonomy, and because of that, they are considered, copyrightable. So essentially, then the Court of Appeals said, no, you gotta retry this again, right? Google tries the Supreme Court to hear the case. It's denied in June 2015. Then new district court trial starts for the fair use part of the thing. They established that Google did copy them. Then now it's just a matter of the first use. This happened in 2016, and the jury decided. And
that was a jury. Yep, I was going to say that's another jury case, which ends up being important.
Yeah, and then in May 2016, they ruled in favor of Google, saying, this was covered on fair use. right? Around this time, just so you guys know, we started covering it. So we started this part of the stuff. If you go to episode 1, that's when you start hearing us talking about this particular, like case, right? Then Oracle appeals for about the first use in October 2016, and then the Court of Appeals again, the higher court, then says like, yep, I think that it should be sort of like revisited again, and in what happened after that, that was in 2018, where the Court of Appeals said, yep, Oracle is right. And that was going to be the end of it, but Google managed to get into the docket of the Supreme Court in 2019, and the Supreme Court finally tried to settle the question and essentially say 6-2 that Google's use of the Java API was within the fair use. So that just happened like a week ago. So we have traveled in terms
a
of
long way.
Yeah, in terms of court time, it was 21 years. In terms for like when the sin was committed, oh my gosh, it started in 2007, I guess. So it's been a long time, and you can see that sort of like Google won the lower courts, but the Court of Appeals was always throwing it down, saying no, Oracle was right. But then the Supreme Court finally picked it up and declared that there is fair use on sort of like even though APIs may be copyrightable, there's still a lot of fair use arguments that you can use if you want to use them. And that's it. That's the end of it of the timeline. Now we can open it up to. Let the floodgates open and let's start talking about this first. Yay, right?
So Bob, I think you probably spent the most time out of any of us with regards to actually reading the verdict and digging into it. What are some of the interesting nuggets that you've found?
Yeah, I mean,
as you've gone through the actual opinions.
Yeah, so just having read it, I mean, so there's if you go to the document, we'll include the document in the show notes. There's both an opinion and a dissent to it. And you'll notice there's only 8 justices, so Amy Conant-Barrett did not vote on it because she was not seated at the beginning, and I'm guessing that.
Yeah, when the trial started.
Yeah, how it
when
works.
Arguments were heard, yes.
So she was not seated, so she did not vote. But the 8-2 nature, so they had both a favorable. Judge Byers read the majority opinion, and Thomas and Alito, I think Thomas penned the dissent and Alito signed on to it. So I think it only makes sense to kind of break it down into both the majority opinion and the dissent, just kind of understand where this goes next, because the ruling doesn't actually, I mean, one thing I will say as a whole is it doesn't put the issue to bed, as with most things with the Supreme Court. They're looking at very specific things in the case. And I'm not a lawyer, so this is just my interpretation of how we read it and how this, and what we're going to try to get into is how do we think this impacts us as developers.
As developers, right?
Based on how they made the decision and what may come in the future because of how they made the decision. So one of the things that they didn't say in the ruling is they didn't really touch on the copyrightability in the majority opinion. They start off the opinion talking about, we're just going to assume that this stuff is copyrightable.
Yeah.
So, I mean, the very first thing they start off with is they're not going to argue whether it's copyrightable or not. They're just going to say, sure, just for the sake of argument, we're going to assume that everything Google did was copyrightable and they infringed on copyright. So everything that they have to say in this opinion, the majority, is focused very, very much on the fair use portion of it, which makes sense, and because that's what Google appealed. And the ways that they kind of approached the fair use, the way I looked at it was very much on the risk of harm of making the decision the other side. And when I say risk of harm, a lot of it is to consumers of technology. What is this? mean to consumers rather than, hey, what does this mean to developers, which is what we're curious of. So, one of the things that they mentioned, I'm trying to look at my notes.
And just to jump in here, this is a document that's available on the web. You can read it. It's a 62-page document, correct? That's the one I'm looking at?
Yeah. Yep, that's right. So it's the opinion issued. They go through a lot of kind of the background, like what Freddie went through. I guess the one thing that I would point out, knowing that a lot of it is focused on the consumer, that is of interest to developers, is they heavily cited the investment programmers take to learn the language as one of the reasons why they found for Google. So the cost and difficulty of producing alternative APIs that, even though that, the APIs were copied, again, we're assuming that they were copied. The effort put into creating brand new APIs would be prohibitive for programmers that write in Java to have to relearn and basically have to adapt their code to, if they were to rule to say that the APIs were not in fair use. So the economics of it would be swayed too heavily in Oracle's favor for them to rule otherwise. Was one of the more interesting things. I'm trying to look at my notes from the ruling. The cost and difficulties of producing alternative APIs with similar appeal to programmers. Allowing enforcement here would make the Sun Java APIs declaring code a lock, limiting the future creativity of new programs. So basically the idea is if you have an interface which checks if a string is empty, which is a Java API, right? If I had to come up with a new is empty method instead of empty or whatever, like every single time, that's a cost to programmers. And that cost of having to do that repetitively throughout the entire set of APIs kills compatibility and all those things.
But it kills off the ability to innovate, right?
I think that was the argument. Like it was like this lock, instead of enhancing the ability for people to have creative work, because copyright tend to be an idea for more people to feel safe about creative works. Instead, if we actually declare the APIs to be comparable, it actually does the opposite, which is impede creative works.
It's not, but if it wasn't fair use, I want to be careful here with how you're saying that, because they didn't rule on anything about the API being copyrightable or not.
But it's like if it was fair use.
Yes, exactly.
Yeah, because fair use is the building on top of existing copyrightable content,
right? Yeah,
and that's basically what they said this was. Is that they said that you have something that was copyright, and you chose to build on top of it. You chose to evolve it into something new. And I know that. I don't remember if this was directly in the opinion or if this was just other analogies I heard experts talk about, but things like taking a character and adding a new dimension to them, or I forget what the other one was.
They used a lot of analogies around restaurants and organization and menus, hey, adding breakfast, lunch, and dinner in a certain order, while, hey, you could create a menu with a copyright, but you can't. It's fair use for me to produce another menu with that same order, as long as I'm not placing the same food items, for example.
Yeah, another one I liked, I heard on, I think it may have been the Java Champions list, was of all the cars, you can produce one kind of steering wheel. It has to be round, it has to follow this particular guideline, but the way you make that steering wheel work can be changed, right?
Yeah, and I mean, that's a good analogy for implementation, because I mean, again, where the focus is on the API itself. So you're thinking mostly interfaces, the things that don't have executable code in the Java API. Google's claim is the implementations were broadly rewrites and clean room implementations that didn't copy verbatim the Oracle code. And it's interesting when you compare the level of copying when they looked at implementation versus the API. So the APIs, the level of copying was almost 100% from Google from the Oracle, the Sun Oracle.
But the total code base was minuscule.
Was drops in the bucket.
Yeah, it was 11,500 lines of code, which typically less than 4% of the total code base. And so that was another thing for Google, in that they're like, you've got this mountain of code, we copied this much of it. It's like copying one paragraph out of an entire book.
Yeah, and that's a good way to say it too, because authors can actually copy certain amounts of text from other books and whatnot, and that's not considered, that you're plagiarizing or anything. Right. It just is a certain percentage. So 4% is pretty small.
Yeah.
Yeah.
Although in the dissent, that's exactly where they went.
Mm-hmm.
In the dissent, that's where Thomas, who wrote the dissent, he went straight onto that. He focused on the copyright aspect of it, not the fair use aspect. He's like, this is a violation of copyright. Like, this was a copyrightable thing, and you copied it. What else is there? In his dissent, Gay basically stopped the train of analysis there.
Right, and I think one of the reasons they did that, one of the differences in the majority opinion, is they started to establish in the majority opinions that it's not all one thing. So they kind of took that there's different ways to apply. Where can we be more liberal with the fair use, and where do we have to be strict? And, what they came down to was that in the executable code, they felt they could be stricter than with the API code. So
which makes sense.
If I was copying implementation code, it's going to be a lot. They made that point kind of, hey, it's going to be a lot harder for you to prove fair use in the implementation, because I have a lot more degrees of freedom the way I can implement that code. And, the economic benefit of just copying somebody's code versus having to rewrite it, it does kind of make things unfair for the company that took the time to write it. But in the API realm, they started slicing away to say, if you're talking about an API, the purpose is for it to be reused. It is very difficult to produce equivalent APIs that do the same exact thing.
Yeah. Sort.
Yeah, sort. I mean, I want to sort two
Order.
things. Well, I'm going to take a list of things in, and I'm going to give you a list out. Do I have to call it sort 1 to make it not copyrightable? I mean, what is the bar here? So, I mean, they're establishing differences between types of code and how they rule on it. And because they didn't rule that APIs are not copyrightable, those pieces are going to be the really important things going forward, because lower courts are going to have to look at that and say, well, the Supreme Court has issued a ruling where they have differentiated between API code and executable code on the fair use argument, because the way I rule should probably be fairly in line with them.
Yeah.
Because not ruling on the copyrightability of APIs means fair use codes are probably still going to end up being in the courts quite a bit. But now we have a little bit of a framework to work with to say, all right, well, if it's an API code, if I'm re-implementing S3, the bar is a lot higher for me to sue.
Not that anybody would have ever done that.
Who would do that?
Like Oracle.
But if I'm doing that, it's going to be a lot higher bar for me to prove that I'm not in the fair use zone of building it than if I were to copy S3's executable code, in which case it seems like the bar is much lower for me to prove a infringement and it's not fair use.
Yeah.
Yeah. No,
I'm trying to think if there was anything else. One of the other interesting things that I noticed in the majority opinion, and it's super subtle, and I don't know if there's any legal basis behind it, but when the majority opinion refers to Java, they refer to it as Sun's creation, whereas in the dissent, everything is Oracle, like its son never existed in the dissent. Just an interesting thing. If you're reading along, you may notice that.
That's funny.
I have no idea why that might be.
If you have any,
But yeah, as far as I'm trying to think of what else I would add to that majority opinion. But yeah, there was, as they were going through the fair use, they kind of proved it point by point of where you needed to prove fair use. And a lot of that goes into the lawyery stuff that I don't necessarily have a ton of experience behind. But the dissent kind of goes through those same pieces. Here's another one. Like the QWERTY keyboard is another example they use. How do you recreate that?
That was something that I just found interesting about the Supreme Court in general in this process. So getting ready to hear this, hear the arguments, I found another Supreme Court case that I felt like it was one that I couldn't understand, which was the copyrightability of domain names. I actually never even found the opinion on it to find out which way it went. But I listened to the arguments, and they spent a ton of time looking for analogies. And I found it interesting that that's really how the Supreme Court works. It's like, how does that relate it to something I know? Related to something like that's how the Supreme Court seems to work, at least in the two cases I've now paid close attention to. It was I found that fascinating, and seeing it again and again in this opinion, the different ways they look at it and the different analogies they came up with, and even like listening to the arguments that they made in court. They tried all kinds of different analogies that just wouldn't stick in someone. Like they really beat up, if I remember correctly, they really beat up Google on some of the analogies they came with. They're like, what you're saying doesn't back up what you're proposing. And I'm happy to see that the justices came around and were able to find an analogy that makes the best sense for them. But something interesting from the Supreme Court perspective that I found in this process.
Yeah, I mean, that was an interesting thing because if you listen to the actual arguments, because they have record of those were recorded, they are beating up the Google attorneys over the analogies. And when you read the opinion, it's exactly what you said. They're finding that the analogies don't fit, and that's why they kind of came up with this, hey, we actually need to separate code from code. There's different types of code. And that's what I feel that was new out of this reading. And here's the point-by-point thing that I wanted to get to. So the fair use of copyrighted work for purposes such as criticism, comments, news reporting, teaching, scholarships, or research is not an infringement of copyright. In determining whether the use is made of a work in any particular case is fair use, the factors to be considered shall include the purpose and the character of the use, including whether such use is of commercial nature or is for nonprofit educational purposes, the nature of the copyrighted work, that doesn't say a lot to me, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, again, kind of getting to the percentages of the API versus the whole code base, and the effect of the use on the potential market or value of the copyrighted work. Again, how much would it cost to reproduce this, the consumer aspect of it?
Well, is that or is that so read that bullet again.
The effect of the use upon the potential market for or value of the copyrighted work.
So I interpret that as less about the cost to re-implement in the same market. I read that as if I were to copy your stuff, how badly do I hurt you?
So I think that's the second part, the value of the copyrighted work.
Exactly. So like Harmony feels like that's a much more direct threat, and that probably wouldn't have held up under that point. Android is not a direct competitor to Java. It's not. They don't compete directly. So by copying into Android, you're not.
It's app developers that want to get into that ecosystem. Versus
exactly. It brings them along, but it doesn't threaten it. It doesn't diminish the value of the thing I'm copying from.
Right. Yeah, and that was in the majority saying that it's different hardware. It's not running on desktop and servers, and that played into the opinion of why they ruled that way. If you were in the same space, maybe it goes differently.
Yeah.
I guess the thing that I struggle with that on that point is, well, what was Java ME? That was supposed to run on small devices.
We're fortunate that the 8 people that heard the case didn't know about Java ME.
Maybe. It kind of brings into a little bit more of what the dissent talks about. And I don't know if it makes sense to start talking a little bit more. Michael, you touched on it a little bit, the dissent focusing on the copyrightability. But one of the other things the dissent focuses on, which is actually strikes me as a fairly significant point against the majority, is the fact that Apple went ahead and did create a language for their mobile platform. Google could have created Go for mobile. I mean, just as an example, the idea that other companies weren't impeded by this and actually did invest in creating new APIs and new languages in order to support mobile as an argument against it.
Now, even that is interesting, because an API is language agnostic.
To some degree,
or I guess
sequence, structure, and organization, right? So that includes packages and where is it on the taxonomy.
I mean, if a language doesn't have public as a command word in the language, as a reserved word in the language, if it were called reserved and then void, would that be enough to avoid copyright? Maybe.
I guess that's kind of what I'm getting at, is for example, having an equals method. Is that did it have to be in Java to be considered copyrightable or a copyright infringement? Did I have to do the copying to Java, or could I do that in language and it be okay?
Well, I think again that kind of comes back to the percentages, right? They didn't just copy equals.
No, I get that, but I'm just
100% of the API.
Well, but that goes to the percentage of use, not whether or not it's copyrighted. Yep. And I'm getting to the I guess what if I were to take the exact a good example here that I think is C#. Mm-hmm. It's amazingly close to Java, right? And so is that could the argument be made that was copyright infringement?
I guess I don't know the percentage that C, Sharp is like Java. It's similar, definitely.
Yeah.
But not
but if you were to take that, let's say the percentage came to, word by word comparison, this percentage was 60%. It's not 100%. Is that
but I don't think
variance to say, hey, you're not going to meet the bar for copyright?
I mean, when you copyright outside of this lens, this specific case, there's a lot you don't have to let's just put it this way, you don't have to copy 100% to be in copyright infringement. No. A good example of that it was actually another recent case. I don't think it was to the Supreme Court, but Andy Warhol has a painting of Prince that is based on a photograph of Prince, a portrait, and the photographer that took the portrait sued, saying you illegally used my work. And if you look at the painting versus the photograph, there's no debating where it came from, but there's quite a bit added to it. I mean, it's Andy Warhol's edition of stuff, right? But the courts ruled that no, that was copyright infringement. They ruled in favor of the photographer. So you bring up 60%. When you compare it outside of this lens, 60% would be way enough to say, yeah, you're infringing. I mean, 4%, less than 4%, that makes sense. But I mean, anything 40, 50% would probably be.
It's kind of hard to quantify, right? That's the problem I have. We're calling it 60% because we're developers and we sort of see the similarities. But if can two developers, you put them at C# implementation. I don't even know developers, but a C# implementation and a Java implementation, like, can they say like, oh, these are equivalent, or these are like a copy from each other? It's tough, right? Like,
yeah. And you're talking about the language and the way it looks and the way it programs too. You're not talking about the platform, right? Because C# goes to a different platform.
Oh yeah, exactly. Right? Well, but APIs, an API is independent of the platform it compiles down to, right? Like, I mean,
right?
No, it's tied up to the platform.
No, it's not, right? Because Android proved that, right? Because I can compile my Java code to Android binaries. I can run it on a JVM, or I can even build a native image now with it.
Well, what I'm saying is, like, if I copy the same code, it will run on both platforms. That's what I mean that they're the same.
But that means that they are independent of the platform, not tied to the platform, which is what I'm saying. The API is independent of the platform it runs on.
So the interesting part is so it's nuanced, right? Because when you say independent of the platform, it's because the interpretation layer can interpret it for both systems, but the interpreter must run or must have the same lexer. The same lexer, which is the input, for you to be able to understand both languages. Like for both my quote unquote Dalvik source code, which is exactly the same as Java source code, right? Like the package names have to be the same. Like so there's.
But that's part of the API, right?
The Lexer code? I guess the Lexer code would be part of the compiler.
Right. That's a translation afterwards. It's a translation of the work after the fact. Like the actual, and that's not what we're talking about. Like we're not talking about everything outside of the text files that are .java files is outside of the scope of this case. This is only the text and .java files.
Well, it's actually part of the part of the Java files, not necessarily all the Java file. No, it does, right?
No, it doesn't. Not for this case, because they're not copyrighting.
The case was focused on the APIs. It wasn't.
Yeah, they're not talking about copywriting bytecode.
Right.
They're not talking about bytecode instructions being copyrightable.
No, but that is the distinction, right? Like it's not all Java. Is those interface definitions that are the Java files.
Yeah. No, I mean,
which is what I'm saying. Like it's the text in the .java files. Mm-hmm. That's as far as it goes. Once it's compiled, different ballgame. Which is why I said the APIs are independent of the platform they run on. There's nothing stopping you from building an interpreter that would run Java and
Java files into what happens with translators? So like those that morph code from Java to C# or to JavaScript.
I mean, you can run JavaScript. I mean, the fact that you can run multiple languages on the JVM just proves that as well. Right?
I mean, again, running the languages and a company copying the code and then shipping it, distributing it, I think is a different case than what you're talking about, Freddie. I mean, again, the idea that I can have something that can run a Java file, I don't think is what was being argued here. I think it was really about the fact that within the source code that you're using and shipping to your consumers and say, here's my API interface, go use this, was exactly the same thing as Oracle was shipping to their customers saying, here's our interface, you use this. And that was the basis of the argument that Oracle was making is you copied the thing that we send to our customers to build on top of. Yeah, the runtime, I think, is outside of the purview. I agree with Michael. I think the runtime is a different question.
But what I'm trying to drive into is the cross, like if my package name is different, is that a copyright violation because they have a sort?
Sounds like no, because
so if that's true, then it doesn't matter. C# can be exactly the same, but it runs on C#.
Well, it depends where are we starting? Because again, on the basis of the majority opinion, the bar for saying this API, you're using an API not in fair use, is pretty high. Like, so what they've established is, you know, if I copied the API verbatim, there have to be, you know, the 4 factors that I listed, there must be a lot of those other factors that are contributing against that API for it not to fall in your lap for fair use. I mean, which could be, hey, you've created a completely competing product on the desktop, so you are actually eating into the market value of Java.
It would be .NET taking verbatim
in that case,
stealing.
In your example, I guess
Java's,
that would be harder, right? But it's not strictly because of the closeness of the APIs together. I think it's actually what they're saying is it comes down a lot more to those other factors, right?
Beyond just
one of those factors are how much did you copy? So that's one of the 4, right? But they copied pretty much everything and they still won as far as the API is concerned. So maybe if the implementation code was so small, the API was a dominating factor, maybe then it factors differently. They didn't really answer those questions. Right.
Just kind of right, and that will be very hard to see where the interfaces are a significant contributor to a code base.
I think what is fair to say though is .NET would have a better case than Android if they were going to sue on that, because again, the competing markets plays against some of the Oracle arguments. You know, whereas. You know, but in the amount copied, it's still small in the overall code base. The .NET implementations with their interfaces is still going to dominate the interface code.
And it's to consider copying. I guess that's
if it's a lower percentage. Yeah, I mean that works against .NET, but some of the other factors work for it. So you're kind of shifting where the levers are in this case.
But this was the thing I'm hung up is like if I change from package to import, which is what .NET uses, am I out of the hook? Like
I don't know. I mean, but if I am Microsoft and I just saw this ruling where Oracle literally had their entire API copied and they lost, am I going to want to spend the millions of dollars to bring to the Supreme Court? Oracle thought they had a watertight case, I think, because they could say, you literally copied our entire API. If you go on the basis that APIs are copyrightable and you can't claim fair use, you got a pretty solid case because nobody's denying that Google copied this stuff.
Copied it. Like I
think Microsoft,
nobody denied that part.
Yeah, the Microsoft case, well, now we're into percentages. Do I really want to take this to the Supreme Court to try to win it? It's probably not worth my time.
I think Microsoft filed an amicus brief on the side of Google.
Right. So, I mean, they're not going to do it because they don't want, I mean, I think with all the past behavior, that works against them in this entire argument. Yeah. But I mean, just on paper, maybe they have better cases because the levers are in different spots. It's hard to tell, but I don't think companies are going to risk it.
Which is nice.
Unless they've got a solid case. I mean, you need basically 100% API coverage, right? You'd need the same market.
Yeah.
Yeah, same market.
Same market. I'm trying to think of the other thing, the economics thing of,
preventing people from the consumer from innovation. How does this square up, for example, with how does it square with DocumentDB?
So that's interesting with DocumentDB. So DocumentDB could easily be said this is a competing product. They both have cloud offerings,
but they just copy the API,
which is a small percentage of.
Which is, again, a small percentage, but they copied the whole API. So, I mean, the levers, I mean, DocumentDB sounds like, I mean, again, based on what we've talked about, the DocumentDB case sounds like a better case than Oracle had, given how the majority opinion was issued. Now, you could also look at it and say, well, there's only a few different ways you can do a DB. Well, you've got a lot of different DBs out there, too.
They kind of sort of agree on
I mean, the DocumentDB case is the fact that they literally copied the API for compatibility.
Like that's the whole reason. What Android did? I mean, I feel like it was compatible so you can use Java libraries and things.
Yep.
I mean, I can use Apache Commons on.
You can almost like copy and paste.
But there were other ways to accomplish that as well. I mean,
but they didn't.
Well, if you read the dissent, you create your own language.
That's true.
I mean, you create Swift.
Funny thing is, though,
that's what the dissents hit them up on.
By copying that, by doing what they did, they actually helped Java, right? So that's kind of the funny thing, because I think that overall, this was a benefit for the Java ecosystem to have every Android developer using Java, right?
With Grado.
Not that they do anymore, but.
Yeah, no, it did. But I mean, some of the things that the dissent mentions, and in the very first paragraph of the dissent, it does mention how the fact that Google just went ahead and did this. Well, not every company went ahead and did what Google did. Amazon was apparently paying Oracle, and this is something I didn't know until the ruling, tens of billions of dollars to Oracle for the use of Java on Kindles. I had no idea they were paying them. I mean, so as a result, erased 97.5% of the value of Oracle's partnership with Amazon, made tens of billions of dollars. Well, oh no, so they're saying Google made tens of billions. Sorry. But the fact that Oracle had a partnership with Amazon for the essentially, the Kindles to license Java out, that is the opportunity cost that the dissent mentions that Amazon or Google robbed Oracle of. Again, for covering this, I had no idea there was a partnership there, but hey, the fact that, you go back in the timeline, the fact that they were trying to negotiate a license, didn't do it, was an argument against, their position that it wasn't economically feasible. You just didn't want to pay the license. Again, that's the Oracle position on it.
Yeah, right. I mean, I think there's more to peel off, right? Like, there are multiple reasons. Like, one of them, it might not be legal, but the other one might be I just don't want to be bothered by it, right? Like there's that I want to get a license does not mean that that's the only way I can get that, or it's not sufficient to say that just because I was looking for a license, that means that if I didn't get a license, if I didn't implement it, it was legal. Which I guess that's why there was a majority opinion on it. But yeah, because I could get licenses because it's just not convenient. Like, I don't want to be bothered by it, right?
Oh yeah, I mean, the dissent cites trust issues were the reason the negotiations broke down. So I mean, I don't know if there's an actual document. It says there's something in the appendix mentioning the trust issues. Can't imagine what the trust issues would be.
They were saying from the timeline. Some was very afraid that Google will fork. That was the thing. Like, they'll start diverging from the TCK and Java compatibility, and you can create two quote unquote Java-like languages that won't be able to be run on each other. That was sort of like what Sun's position was when they didn't get a deal. Google's position was that Sun wanted to have a percentage of each particular, like every installation will have a percentage of revenue going to them, and Google didn't want that. But I guess, and I know we can keep going this forever, but I guess the interesting part is, as it stands right now, we don't know the copyrightability of APIs. That hasn't been answered. But as far as we understand it, there is a very high bar to say that if you implement somebody else's API structure SQL organization, that it was not fair use. So for you to get in trouble by implementing somebody else's or quote unquote copying somebody else's API, again, I don't know I'm not a lawyer. The Supreme Court said in this particular case, it was fair use. Chances are, and Google copied a lot of it.
Yeah. And just to get my facts right, I was looking at what Oracle was charging Amazon. It was $40 million, and they dropped it to $1 million after Google did what they did, because they said, "Hey, it's not worth us to pay you $40 million if we could just do the same."
Do what Google?
So the 97% is 40 million license fee down to one.
Yeah. In the end, I think this was a pragmatic opinion. You know, they chose not to take the broad brush, but they also they did seem to heed the warnings of Google by
Microsoft and a lot of people.
For ruling the quote unquote wrong way here, and how it would have upended the software development industry. And so it feels like they took a very pragmatic, narrow verdict. It leaves a lot still to be interpreted, but it's as close to a win as we can get. And the fact that it was also not on the party lines.
It wasn't like 6-5 or like, yeah, right? Like,
yeah, it wasn't 4-4 or 3-5. I guess it would have been 3-5 in this case if it went down party lines. That wasn't the case. It was 6-2, which was really good.
That's good. Yeah. No. So we live to fight for another day. And hopefully, yeah, like this just, and again, the concern is that if I wanted to, you know, like it almost becomes copyrightable. Would somebody come out like, you know, with some like old REST definition before it was the standard and say this was my doing, and if you use this verbs, that's my copyright, you know, like all this kind of like scary things that sometimes come out of the woodwork. You know, at least it's not that they'll never come up, but there's a lesser chance of them coming up. And that's a good thing. You know, I can just keep working and trying to figure out why my auto scaling is wrong.
I'm just glad coming out of this, we don't have to worry about the equivalent of, do you guys all remember SCO in the Linux? Yeah. The whole patent troll around Linux back from the early 2000s. Because if this went the wrong way, there'd be a whole lot of lawyers gearing up for
there'll be a lot of money.
Patent law is still fairly interesting. So, I mean, that's one of the things that got this into kind of interesting territory is the fact that it had to do with the copyright. They ruled on the patent, and they kind of left that be. But yeah, they went after the copyright factor here, and I think if anything, we'll just have to see where it goes because I think the ruling does open up copyright use as having a high or a low bar for fair use. So a very simple thing for fair use. Now, whether that leads a bunch of document DB clones or where that maybe breaks down with large cloud providers copying every API and just, people are worried about them edging people out of the space.
Yep.
What'll be interesting to see is as cases and other cases will probably come up through these fair use arguments because they haven't really settled everything is where the toggles lie on the fair use and when you finally get to the point where it's like you copy the API and this is not fair use anymore. Because I'll be interested on the first ruling that goes the other way because then you actually see
the high bar.
This is the limit. This is as far as
start to see what the range is.
Because that's the unanswered question for me.
Yep. It may also be that these are just all custom circumstances. I mean, it's possible that there is not just one brush that you can take and paint over the whole thing and say, this is, the line that you draw that considers it to be copyrightable or not.
Yeah, well, I mean, that's what the Supreme Court tries to do, the analogies, right? But hopefully, even if they try to draw a line that is a very, very broad line, making it easier for us to do our jobs. That's not what we want to.
What would really help is if we had some legislation just to deal with this issue where it was a law.
Right? Let's say APIs are not copyrightable.
Obviously, it's a very thorny issue and a difficult one to get right. But I mean, again, I think, if anybody's out there listening that has strong feelings about, whether API should even be copyrightable in the first place,
right.
Clearly a law that would say APIs are not copyrightable, period, would pretty much put this matter to bed. And then you probably reduce the court load on any of this.
I mean, let's not kid ourselves. Copyright reform in general could be useful. I mean, the whole Mickey Mouse law and like all that stuff. Like copyright is rife for abuse, and just the fact that this got all the way to the Supreme Court just illustrates that. Yeah, the copyright reform in general is needed.
It's needed.
In the U.S.
Yeah, I mean, just look at all the stuff that Apple and Samsung have gone through with the iPhone and whatnot. You know, that whole thing definitely needs reform.
Well, I think we are up to our change mark. And like we said, we can probably talk this forever, but this is a good stopping point for picking up on the next OffHeap episode. So let's leave it at that. This is Freddie signing off.
This is Bob. I am not a lawyer, Paulin, signing off.
Yep.
Josh signing off.
Michael signing off. If you're on Twitter, follow us at OffHeap. If you're watching us on YouTube, be sure to like, share, comment, and subscribe.
Yes, please do. All right. Happy programming, everyone.